Good evening, everyone. I'm Rakhi Gautam from greytHR, the moderator for the Parichay webinar session today. First of all, thank you so much for taking out the time and joining us on this webinar, which is on a very anticipated topic. I'm sure all of you are just eager to listen to all the insights that the expert has to share today. So, as you know, the topic is breaking down the draft Digital Data Protection Act rules. Now, before I dive into the topic, let's do a little housekeeping on how the session goes. So, the session is divided in two parts. The first part will be the discussion with our expert, which will then be followed by an audience Q&A. So, audience Q&A is where time is all yours. You can start putting across your questions in the Q&A option, which is there available on your screen. And we will take those questions towards the end. Also, this session is currently being recorded. So if you happen to miss out on anything, do not worry at all. As I always say, we have got you covered there. We will share the recording of this session with all of you very soon. And this also will be available on greytHR's official YouTube channel. So you can always go there and watch it later. Now, before we start, I think we already have the quorum with us. But if you want to share this link with anybody, in your circle, in your network, any of your colleagues, friends, family members who you think would benefit from this session today, you can just share this live link with them and they should be able to join. So, okay, without any further ado, let's start the discussion. So, with data privacy taking center stage, the draft Digital Personal Data Protection Act rules introduce critical mandates on data retention, deletion, and compliance. So, how will these regulations impact businesses? What steps should organizations take to align with the new framework? In this session today, we will provide a clear breakdown of the draft DPDP Act rules, discuss key compliance challenges, and share practical strategies to ensure readiness. So, if you happen to, if you are an HR professional or an employee or somebody who's just eager to understand this digital era and how data works in this digital era, be ready to engage in interactive polls and live Q&A session that we have, and let's keep the participation at the maximum, because this is such topic where the more participation that we get from the audience, the better it will be for us, as well as for us to provide a comprehensive and great experience to all of you in understanding that very complex topic. And to decode all of that, we are thrilled to have with us today Miss Mehak Khanna, partner at Khaitan and Khaitan. Let me quickly take you all through her profile. Now, a lot of you are loyal audience. You have been attending our sessions for so long, so you would remember Miss Mehak joining us a year back when this was introduced. Of course, it was in a very nascent stage back then, and we did have a discussion that time also, where a lot of questions were on the procedures of it, right, which we would be taking in our discussion today. So let me take you all through her profile. Mehak is a seasoned corporate lawyer with an impressive 15-year track record in law firms and in-house legal roles. Her career spans advising both large established companies and fast-growing tech startups along with investors. She has led complex restructuring and M&A transactions, excelled in contract drafting and negotiations, delivered top-tier corporate advisory services, managed real estate deals, and adeptly handled technology, IT, and data privacy contracts and compliance. She is a recipient of prestigious awards such as ET Prime Women Leadership Award 2021, Asian Legal Business India Rising Star 2021, Forbes Under 40 Top General Counsel 2020, and 40 Under 40 Rising Star Award by Legal Era 2020. Now, as I read the introduction once again, I'm just so thrilled, and it feels like a privilege to have you here with us today, Mehak. Thank you so much for joining us.
Thank you so much, Rakhi. It's a pleasure to be here again. And what better topic than, these rules to have a brainstorming session on. So thank you so much to you and the, greytHR team. And very happy to be here. And yes, let's start. And thank you so much for all the support and kind words. So special thank you to you as well.
Thank you so much, Mehak. Looking forward to a powerhouse conversation today. But before we start with the first question, I just want to understand from the audience their perspective and their understanding of this DPDP Act rules. So I'm going to launch a poll now, and it is launched. I would urge each one of you in our audience today to participate in this poll. It's not a right or a wrong question. This is just to understand your perspective so that, when we are having this conversation, we can tailor our responses accordingly. That will help you understand this to the maximum. Okay, another 10 seconds. The rest of you who haven't participated, please participate. I will give virtual kudos to everybody participating in this poll. Okay, I'll end the poll now and also share the result with all of you. So we have 35% who's saying just starting the session is my first deep dive. Great. We are happy to have you here. Somewhat aware, need more clarity. That's 34%. 26% not aware at all. And only 5% with very familiar, already working on compliance. Got it. Thank you so much, everybody, for participating in this. And great, then let me start and shoot my first question to you, Mehak. A very basic one, of course, to set the context and to understand this in detail. Can you break down the key objectives, first of all, of the draft DPDP Act rules in simple terms, and why should businesses be paying close attention to these changes?
Sure, Rakhi, I'll do that. I think just to give a quick recap, so we had the Digital Personal Data Protection Act that was notified in 2023. And, just so that everybody knows, that particular law is the first law of its kind in India that is going to be regulating the personal data of its citizens. So, with that context now, what the government has done is last month in January, they came up with the digital personal data protection rules. And these rules have been brought in to operationalize the DPDP Act, which was notified in 2023. So now what does, this law mean for us, in layman language? So the law, which is the act that was notified in 2023, and now these rules that would make it operational, they provide a framework for the citizens by which their personal data is going to be protected and regulated. And the government has brought in this law to ensure more transparency and accountability in respect of how the data is managed and handled in our country. Why businesses need to play sort of pay close attention to these changes, and be on board with this whole project is because this is the first law of its kind. We didn't have a specific legal framework dealing with the personal data of citizens before this in our country. Of course, there have been other global laws all around the world, including GDPR, but in our country, it's the first. We had an Information Technology Act, we still have that, but that deals with various other aspects. And one of it was also, protection of personal data and sensitive personal information. But this is the first time that a dedicated law is going to be brought in India, and the non-compliance of which is going to entail massive penalties running up to 250 crores, which is why the businesses need to pay more attention, because this is the time where they would have to fulfill their responsibilities irrespective of whatever the cost of compliance might be, considering there are strict penalties involved. So this is where it's going to be a catch 2022, because they will have to start from somewhere. on a lighter note, maybe catch 2023. But yeah, that is the hold up between compliance and cost. So yeah, we'll deep dive more into it, but the businesses would have to comply with it.
Sure. Thank you so much for that, Mehak, and setting the context, of course. Now, you did touch upon this, but to, again, as you said, deep dive into this, how do these new rules differ from previous data protection regulations? And what kind of impact do we see, on the businesses, both large and small?
Um, so these rules are the first of its kind to be introduced. They have been introduced to operationalize the law that was notified in 2023. They are somewhat similar, but they also differ from the earlier regulations that have been there in Europe and specifically GDPR, and also those that have been there in US and Singapore for that matter. Um, Having said that, the basic principles remain the same, but in the Indian context, what the government has done is that they could not have brought in a law from Singapore or Europe and sort of implemented it as it is. So they've picked up on similar principles of taking somebody's consent before processing their data, and taking consent before transferring their data, ensuring that there is proper consent in place, ensuring that the data principal, that is the person whose data is involved, those rights are protected. So they've taken on these basic principles, but they've customized it in the Indian context. So, for example, under the GDPR, which is in Europe, there is no such concept of a dedicated consent manager. Also, the DPDP laws in India, they categorize fiduciaries as, certain e-commerce fiduciaries and then significant data fiduciaries, so on and so forth. Um, and of course, the exemptions in India where the data can be used for legitimate purposes by the government, all of that is something which is way more customized, because in India it can be used for statistical purposes, archival purposes, so on and so forth. So yes, the principle remains the same, but it has been customized. Nevertheless, for a lot of people who've not been aware of GDPR or the Singapore data protection laws or the US data protection laws, for them, it is going to be a clean slate to read this particular law and implement it, from scratch.
Thank you for that, Mehak. Now, as in my introduction, also I said that okay, there have been these introductions, critical mandates related to data deletion, data retention, right? So let's talk about that. When it comes to data retention, what do
Mhm.
businesses need to be aware of? Are there any specific timelines or obligations they should start preparing for? What is this whole thing about when we say okay, data retention, and you have to be on top of it and you have to ensure that you're compliant?
Sure, I think I will come to data retention and deletion, but I think just to also pick up a little bit of context there, there are going to be implications on businesses. So it is, something that they would have to now imbibe as a matter of practice. They would need to have robust frameworks. They would need to have more automated setups. They would need to have more focus on data tracking and data monitoring practices. They would need to train their employees. They would need to spend money in having a team that is focusing solely on data tracking and ensuring that there are no adverse incidents. So, in this context, it is important to also mention that there would be certain measures that they would need to take because this will impact them. Now, those measures can be technological in nature, organizational in nature, those can be, pertaining to employees. So, just to lay the context that there is going to be that impact on every kind of business, big or small, they will have to set aside certain cost to be able to start dealing with this particular law and its implementation. Now, coming on to data retention, of course, this particular law does provide for data retention. What they're saying is that there are certain classes of fiduciary, e-commerce fiduciary and certain other fiduciaries that they've categorized as, and they are saying that unless you require it for any other purpose, whether you're an e-commerce fiduciary or a social media intermediary or an online gaming intermediary. So unless you need it for a purpose under law for a larger period, you should be able to retain the data for 3 years from the time these rules kick in, or 3 years from the point where you get the consent, whichever is the later on threshold. So 3 years is a longish period, but yes, that is something that has been taken as a base, which should not be very difficult for businesses to comply with, because it's not 12 months or 18 months, it's a 3-year period, of course. Um, the threshold is from the time the rules kick in, or when the request from the data principals came in, whichever is the later one. So that is regarding data retention. In terms of data deletion, that is also a right that the data principals have. So they can go back to the data fiduciary and say that they want their data to be deleted. Having said that, whenever the data fiduciary, the one which is dealing with the data, they decide to erase the data, they have to inform the person whose data they are deleting at least 48 hours in advance, telling them that their data is going to be erased unless they log in or they initiate their contact with the fiduciary. So this is something that has been also put in just to ensure that if they take proactive steps, they can prevent their data from being deleted. Having said that, I mean, the right of the data principle has been made very clear that they have the right to review their data, they have the right to ask for erasure, and of course, they have the right to ask for their data to be deleted, especially after the retention deadlines, which the businesses in any case would need to do. So this is how the retention and the deletion aspect would work.
Understood. Now, when it comes to data deletion, right? There, many organizations might struggle with the policies. So,
Mhm.
first, what are some of the biggest challenges that they might face under these new rules, and how can they address them effectively that, they don't come under that scrutinizing, so how can they avoid that, and how can they be again compliant with it?
Um, it's a very good question, because the paradox is that while this particular law puts the obligation on the businesses to start preparing, it's also difficult because one doesn't know where to start from. So just to probably break down the measures, I think firstly it would be extremely important for organizations to do an audit of the kind of data they have, to just do a basic due diligence, check their preparedness. They would have to see, how much of data is online, how much of data is in hard copy form, and they would have to check their internal security and privacy practices, and just sort of get an idea of how much data they are collecting and what all they are collating. Once they do that exercise, then maybe they can move on to the technical or the technological aspect of it, where they would have to figure out what kind of systems to employ, how much of data can be automated, how the data is to be secured online, what all data has to be encrypted, what all data has to be anonymized, what all data has to be retained. Some of the data that is of no use can even be deleted. While doing this exercise, they would have to probably segregate that data between useful data and non-useful data, and accordingly figure out their hardware and software mechanisms. Then I think the third is the documentation related measures, that once these two steps are done, then I think it would be important to focus on the documents, on what kind of consent notices need to be sent to people to take their consent, how the company policies need to be revised, what kind of robust incident response plan need to be there, how the consent is to be tapped and the history is to be maintained, what are the vendor and the user controls. So it would be important to have all of that checked as well, because like I gave an example for data retention, if one has to track the last 3 years from the date of the last consent or the last interaction of the data principal, if that's the threshold, then somebody in the company would have to monitor how these consents are being taken and the timeline for these consents. So this is not making the job any simpler. On the contrary, this is imposed obligation on businesses to be able to go down and check everything at the micro level with that much of granular detailing. And of course, when they do all of it, there are going to be issues that they would have to foresee. I think one, of course, in terms of the manpower, they would need people on the technical side, on the HR side, on the business side, on the legal and compliance side, and they would need to have proper coordination amongst all of these teams and all of these verticals. Because, of course, when it comes to data and when it comes to all of these granular details, one can't have people working in silos. Secondly, I think it would be important to categorize their vendors. I mean, how many people are they sharing the data with? One is, of course, doing the entire exercise of how much data they're holding, but also the exercise of, who all they're sharing the data with. Because one aspect is the data collection and the data coming to the companies, the other is who all they're sharing with and who's processing on their behalf. And, how many data fiduciaries are there, and then accordingly sorting out the documentation with them. So that is going to be another exercise that they would need to be prepared to do. And I think thirdly, it's important to figure out all the the technical softwares and the algorithm side of things to see how the hosting, display, uploading, publishing, transmitting, storage, and sharing of data is happening. Because a lot of times, different teams are doing all of these activities in different software and through different means, and it's important to sort of make it streamlined, make it uniform, so that the traffic of the entire data can be controlled. So I think these are a few steps that I would expect companies to start, preparing for. And yeah, this is probably just the beginning. And apart from all of this, having people dedicatedly working to dealing with data issues, whether those are, internal data protection officers or grievance officers. And even if it is not a requirement to have a data protection officers, we are seeing companies hire data protection officers or data privacy managers solely for the kind of expertise they bring to the table. And I think that's extremely important as well, especially with the kind of detailed obligations that the government intends to impose on the companies.
Thank you for this, Mehak. I think this was very, very helpful, and I hope the audience has taken notes on these pointers as to what they can do right now, as the initial steps to prioritize on working on these new DPDP Act rules. So, thank you so much for sharing that. Now, before we move on to the next question, I just wanted to again, understand from the audience about how confident they feel are they with these new rules. I'm just going to launch the and yes, and what of course is their biggest concern regarding this DPDP compliance. So I've launched the poll question now. What is your biggest concern? Is it data retention, data deletion requirements, managing consent effectively, cross border data transfers, avoiding penalties, and legal risks? So, we did discuss upon data retention and data deletion, and Mehak also shared a lot of these useful, actionable tips for organizations to start right away with in order to prioritize on DPDP compliance. But yes, would love to hear from you all. What is your take on this, and what do you see as the biggest concern? Okay, another 10 seconds, and then we'll see the results. Okay, I'll end the poll now. And let's see. So 35% has avoiding penalties and legal risks. 29% data retention and deletion requirements, 22% managing consent effectively, and 14% cross border data transfers. So, thank you everybody for participating in this. And what I can understand from this is, of course, all of this are very important again. And of course, it's valid for you all to have these as biggest concerns, because when we talk about data and the usage of data and the transfer of data, currently, especially in this digital era, it's very crucial that you are compliant whenever you are using data in whichever form for whatever activity, right? I just hope with this webinar today you're going to get a little maybe better. Of course, you all are experts here, but better at managing your data and being compliant with these new DPDP Act rules. Okay, quickly moving on to the my next question, which is, of course, when we say there's often a tension between compliance and operational efficiency, because we have to manage everything so much, I would say, at the back end, and but then whatever operations that you have or the tasks that you have at hand should not be compromised either. So how do we balance this out, right? So how can organizations, according to you, Mehak, strike a balance without slowing down businesses processes while being compliant with these new rules which are coming up every day?
Sure. I think the focus should be firstly to sort out the high risk items. I think once the internal audits and the checks are done, once an organization knows what the data is, what the data streams are, what is the type of data, and they start the documentation with their vendors as well as the users, and they start sending out the privacy notices. All of these processes can be streamlined if the focus is on high risk first, and then coming down to the lower risk items. Because while of course there are high penalties, but we know what the high risk items are. For example, of course, even in your Q&A, everybody spoke about the penalties. So the breach in observing the obligation by a data fiduciary attracts the highest amount of penalty, which is 250 crores. And then the breach in observing the obligation to give board or the data principal a notice if there's a breach, that also invites a high amount of penalty of 200 crores. And then, of course, if there's a breach in observing obligations in relation to children, there's a penalty of again up to 200 crores. So all I'm trying to highlight is that wherever there is a higher amount of penalty, and especially if you look at the examples that I mentioned, automatically those items become high risk items. So it is important for businesses in terms of their internal operations and their data streams to categorize certain steps and certain actionables as high risk and certain as low risk, and then accordingly proceed with it. So that's one. Secondly, I think it's important to focus on automated processes. Of course, automated processes do reduce a lot of human intervention, and over a period of time there is going to be operational efficiencies as well. But it is important to have those automated processes coupled with employee awareness programs and trainings and regular workshops, and scenario based learning for the employees, and just even for the vendors, in order to keep them updated of the real risks that exist. So I think these two, three steps, of course, would help. Another, thing which I feel they should do is to come up with clear mechanisms, um, in respect of wherever they see there can be, leakages or breaches, because the businesses, after doing those internal audits and checks, should be in a position to be able to identify the leakages. And if they've been able to identify the leakages and the gaps, they should fix those first and keep a tab on those gaps. And slowly, while tracking those gaps, it would be helpful for them to be able to avoid any bigger adversities and any blunders. So I think that is something that they should also do. So while focusing on high risk items, they should also focus on the inherent gaps and the leakages that exist so that they can plug those and prevent any major issues from, you know, going out of hand. So I think that is something that they should focus on.
Definitely. Thank you for sharing that, Mehak. Now, you did touch upon employee awareness training and vendor training as well. But if there are any, best practices that you would recommend organizations to implement while, having these employee awareness and training and ensuring compliance, anything that you would like to recommend to our audience today?
I think maybe trainings that focus on more of, role specific sessions. I think that is something that helps. And secondly, have more interactive and scenario based, learning sessions. I think these two things is something which would be more helpful in creating awareness compared to a general, uniform based training pattern. Because what happens is that apart from the usual workshop that one does, and apart from the usual sessions that a company has, and the usual, policy training and manual training and so on and so forth, it is also important to be able to do these specific one-to-one sessions or these specific, you know, um, scenario based learning sessions where people can raise practical issues, because a lot of things do get lost in translation, and it's important to be able to advise someone while knowing what the actual issue is. So I think when somebody explains a real world risk, it is easier to tell them how to handle that. And these, sort of drills also help in reinforcing the safety practices, and these, then put things into a better context. So for example, if there's somebody from the HR team or somebody from the IT team that is struggling with a particular problem with their software, or if let's say there's a major issue with the payroll software, with the way it works, they will be able to raise it better in these sort of specific training sessions versus a generic session just to understand the law. So I think it is also important to be able to have that, proper human touch and foresee all of these realistic scenarios and human errors, and currently the ongoing data leakages and data breaches, to be able to develop a comprehensive data protection strategy. Because just having a policy or just having an automated software is not going to do the job. It has to be an overall, sort of coordinated effort to have all the departments work in proper synergy to be able to achieve the goals and avoid these kind of high penalties.
Thank you for that, Mehak. And of course, as you said, of course, there's technology, there's automation to help you do that. But until we have these proper training sessions or one-on-one sessions, where we are making our employees aware that okay, this is how it works and this is why it is important. Not everything can be done with technology until you know how to use that, as per a scenario that you have in mind. So, thank you for sharing that example. Now, coming to my next question, which is, of course, everybody is eager to know that, and you did touch upon this before as well, but non-compliance, of course, always comes with risks, right? So, what are some of the potential penalties under the DPDP Act, and how can businesses proactively mitigate these risks? You again shared those pointers, but if you could elaborate more on that and on the penalty bit as well.
Sure. I think in terms of the penalties, the highest one, or if there's a breach or a violation on the part of the data fiduciaries, to take reasonable security safeguards, and that goes up to 250 crores. So it's important to take all safeguards, at the organizational level that I spoke about, the technological level that I spoke about, the documentation level that I spoke about, and also at the human level that I spoke about. Secondly, of course, there's a huge penalty if there's a breach in the obligation to notify the Data Protection Board and the data principles. So what this means is that under the new rules, we know that there's going to be a data protection board. If it's going to be a professional and a dedicated board, which is going to be like a tribunal that is going to be solely hearing issues and cases arising out of violation of the data protection law. So, whenever a data breach would happen, there is a requirement on the company that they would have to immediately inform the person whose data has been compromised, and they would have to immediately notify this particular data protection board. And if they don't do this, then the penalty can extend up to 200 crores. And of course, apart from this, if somebody is dealing with the data of children, or somebody is dealing with the data in the capacity of a significant data fiduciary, and there are breaches on their part, so there are penalties for that. And then there are penalties of, if somebody does not give the voluntary undertaking that they're supposed to under the law, and so on and so forth. And then there is a residuary penalty also for any other provision or for the breach of rules, which is 50 crores. So, fairly high amount of penalties, not running into thousands, not running into lakhs, but running into crores. And one can make out that the intent is to have high amount of penalties so that the businesses do not default, because if they do, and if they pay these kind of fines for each default, then you can imagine the kind of hole it's going to burn in the cash flows of the companies. So of course, this is something that they should absolutely avoid. And like I said, it's important to invest in technology. It's important to set aside some budget and invest in dedicated teams. It's important to invest in compliance and legal professionals who can, conduct the legal audit and the compliance audit and start advising the company on how to proceed further. And of course, it is extremely important to invest um, on the user side as well as the vendor side, to be able to ensure that proper documentation is there, and it's there in the manner which is going to stand the test of law, and also have it in time, because for organizations that have vendor contracts running into crores, where they're sharing all of this data, or where they have users running into millions, it's important that they have the documentation in place, because ultimately, like we've seen with past laws as well, it can't be a 5-year 10-year exercise. Whenever the government brings in a law, and from the time they notify it, they do give timelines which are reasonable in nature, but then those cannot be stretched up to 5 or 10 years. And so that's something that as soon as the government notifies the rules, they would definitely inform about the reasonable timelines for implementation that they are looking at.
Understood. Thank you for this, Mehak. Now, this has been a very comprehensive and insightful discussion for sure, and a lot of key takeaways from this conversation today. But to sum this all up, I just have one last question from you, which is, now that this new law has been introduced, and we've been talking about how in Europe we have GDPR, right? So, looking ahead, how do you think these regulations will shape the future of India, and especially in handling data protection in India? Like how it's going to be like. And again, you have mentioned what organizations can do at their level, but what do you think? Is it going to be something that will have like a major impact on how businesses operate today, and not just businesses, individuals as well? We have seen some rules for being on social media as well if you're not above 18. So how do you see this shaping the future of data protection in India?
I think this particular law will definitely play a very big transformative role in the way we just, perceive and deal with data, because um, all over the world, data is being treated as the new oil. It's been a while that everyone has been saying that, and considering our country's population, I think it was high time that we as a country moved towards stricter privacy and security standards, because um, whether it's us as citizens or whether it's the businesses or whether it's the government, it was time that everybody had to move to a more transparent, accountable, and a more secure way of dealing with data. Because if you look at what's happening in the current context, we've moved towards digitization, but we've not been able to stop the menace that digitization comes with. There are cybersecurity frauds, there are cybersecurity breaches, there are cybersecurity issues. Do see, people's Aadhaar cards and PAN cards um, being available on social media, so on and so forth. I mean, I don't want to go into the details, but that's the current scenario that we are talking about. So, if we need to reap the benefits of digitization, it is extremely important to be able to have proper sanitization in the process in which we collect, store, and process that data. Because ultimately, digitization can only help to an extent. If the fallouts of digitization are going to be more than the advantages, then one would have to do a rethink. And which is why this has come at, a very, very correct and opportune time. Because in addition to, the way it's going to place India in terms of having been able to integrate data privacy into its systems and policies, and the way it's going to align with the international standards now. Apart from all of that, it is also going to give its citizens the right to make the companies, businesses, as well as the government responsible with the way they treat their data. Because that is something which is very basic, but something that we've not seen happening till now. So I think it was about time that this happened. And yeah, I mean, it couldn't have come at a better time when, we're seeing what is happening around us. And just to sort of put it in a context that even when a data breach happens, leaving aside the fact that authorities need to get involved, and if it's a fraud or a cyber crime, police has to get involved, just looking at the company's approach, or an organization's approach from an organization's perspective. So they do not have to do much in today's scenario if such an event happens, which is why I think from their perspective now going forward, once all of these laws and rules are notified, they would need to share the burden with the government authorities as well, because they would have to inform the board, they would have to inform the data principal that a data breach event has happened. They would have to secure their systems, they would have to investigate and evaluate what has gone wrong. They would have to, then have proper processes if at all there has been, something at their wrong that is, something at their end that has gone wrong. So they would have to strengthen the measures. They would have to address their weaknesses. They would have to do the entire exercise of the post breach event protocols also. So I think in that sense, a lot of the obligations that were earlier just of the government and the government machinery and the police and the government authority now somehow gets shifted to the businesses also, so that they are aware that they need to take the entire process seriously, and not just by virtue of the law when they are dealing with the data, but also when a data breach or an unauthorized event happens, and even post that, with the way they are supporting people whose data has been compromised. So I think in that sense, it's going to be now some sort of shifting and sharing of responsibilities as well.
Great perspective there. Thank you so much for sharing that, Mehak. And this has been a wonderful conversation today with you. A lot, I think, we discussed, and a lot more to explore as and when these actually start getting implemented as well. And as you said, it was about time that Digital Data Protection Act was introduced and implemented, because as we say, right, this is a technological era, this is a digital era that we're living in, and there's so much data transaction which is happening like literally every second, right? So how do you manage all that and be compliant and stay compliant is everybody's responsibility, to an at an organizational level, to an individual as well. It's very important to be responsible and to stay compliant. So thank you so much for sharing all the insights that you did today. And I'm sure I would want to have a recap of this, and I would want to rewatch it again, to get into the details, to see when I'm applying it at my level, how I'm going about it, and what is it that I need to take care, and be sure that I'm ticking my I'm checking all the boxes in terms of being compliant. So thank you so much for this discussion today, Mehak. And I will quickly move on to the audience Q&A. There's one question that I can see right now, but I would urge each every one of you who have been here to start putting your questions now. We have some 10 minutes with us, and we'll try to cover as much as we can. Okay, so starting off with the first question, which is from Namrata. How DPDP aligning with other country data privacy laws such as GDPR, Singapore, PDP when dealing with cross-border data transfer?
That's a good question because I think we'll have to probably wait for the government to get back on the actual position, because when it comes to international data transfer, the government of India says that they may notify certain requirements, with which data fiduciaries will be required to comply with the prior to sharing or transferring the personal data outside of India, and whenever they're sharing it with foreign states, entities, or agencies. So it looks like that the government does want to set some standards, and they do want to bring in some rules. And only once they do that, depending upon what we see them doing, we'll be able to comment further. But yes, this is something that the government has not addressed right away, but they've kept it to themselves to say that they will notify this in future. So let's see what they come up with in terms of the terms and conditions for transferring the data outside of India, and then we'll probably be in a position to comment on this.
Sure. Thank you for that, Mehak. Moving on to the next question, which is from Sangita. We maintain the employee docs in hard copy forms like identity proof, address proof, offer letter, appointment letter, resignation, release letter, and employee information form. When an employee resigns, what documents should we hand over to the employee, and what type of documents we can keep with us? Because we would need that for audit purpose.
So whatever, uh, again, when it comes to processing of data, if it's required by the company to keep the employee data for the purposes of labor laws, then that's something that you need to do. So nobody's saying don't retain the data, because something as basic as an appointment letter, offer letter, address proof, all of these letters you would need to be able to comply with the labor laws to be able to process their payroll, and so on and so forth. So this is basic data. It's just that for as long as you're keeping it solely for the purposes of complying with the labor laws and not keeping it for an extended time period or for any other extended reason, it is okay. And of course, you would need it for audit purposes. You would need it for also your records, just in case, an issue happens or and an employee happens to sue you. So of course, keep all of that data. Just ensure that the way you store it, the way you process it, with who all you share it with, the way you retain it, and then once the purpose is over, the way you delete it, all of that is taken care of.
Understood. Thank you so much for that, Mehak. Moving on to the next question from Sahil Thakur. What potential challenges do organizations face in implementing these principles, and how can they address them to ensure both compliance and operational efficiency? I think we did discuss this, but
Yeah.
if you would like to.
Fine, we did discuss this. So the challenges are going to be from a cost side, challenges are going to be on the resources side, challenges are going to be just to keep a track of the data, just to know what all data is there, or what is the data traffic, what is the data stream, from where all is it coming, where all is it going, who all are using it, in which form is it safe. So I think just doing these basic exercises would help. Once a basic internal check is done of what all data is there, then it becomes easier to employ the organizational, technological, employee driven and documentational measures that I spoke about. But once the length and breadth of the devil you're dealing with, it becomes easier to be able to prepare for it, because then you will exactly know what all resources you need, how many resources you need, whether you need more resources on the technology side and in your IT teams, or whether you need more resources on the HR side, or whether you need more resources on the legal side. So I think once you do that exercise, you'll be able to quantify the issues, and be able to quantify the resources and as well as the related cost, and you'll be able to proceed better. And then having a balance with compliance and operational efficiency won't be a problem. It's just about starting and figuring out what to do. The rest becomes easier.
Sure. Thank you for that, Mehak. Next question is from Shailesh M. Shah. There's an exemption for data provided for employment purposes. What would this cover? Would it mean all data of the employees or interns provided by them to the employer for any purposes is completely exempted? Or how is this?
So I think what the government has done is they've said that there are certain exemptions where the state can use the data for a certain purpose, and for that they don't need specific consent. I'll let me just open that schedule because it's a specific schedule. um yeah. Yes. So this is under your Rule 5. So they're saying that the state can use the data for a legitimate purpose, and as long as it is meeting the thresholds of whatever they've mentioned, it is fine. Also, uh, I'm not sure if you're talking about, Schedule 4, but I'll tell you the exemptions that have been provided, at least under the rules, are for the state, which is your state government, for the purposes they are using it for the purposes of, using any data which is in the interest of a child. Thirdly, for the purposes of issuing any subsidy, benefit, service, certificate, license, permit. Then, for security and sovereignty of the country. So, in respect of employment or employee, there is not much that at least this particular rule talks about. But you mean in terms of the law which was notified in 2023, that also, that mentioned that, as long as you are maintaining all the HR documentation and you're taking those consents while maintaining the HR documentation, then you should be okay. I'm not sure which particular or specific provision for employment you're referring to. So you can mention the provision, I can maybe address it, but yeah, these are the exemptions that I've spoken about because this is what the rule deals with.
Sure. Thank you for this, Mehak. Shailesh, if you need anything specific, you can again connect with us and you can ask your question. We'll take that up. Moving to the next question from Nisha K. The damages or penalty that is being levied goes only to the government or to the breached party?
So it depends. If it is a default of the law, then it would go to, the government, the way it happens with default of any other law. If it's default of Companies Act, or if it's default of GST laws or tax laws, or, it's like any other penalty. So if it's a default, under this particular law also, it's the similar principle. It's going to go to the government, unless of course, it's in a personal capacity that the person who's data has been breached, which is the data principle, he or she sues the company, and then the court also separately awards damages to the person who sued. So that can also be a situation. And yeah, in that case, one would need to see how much of damages are awarded.
Okay. Moving on to the next question from Sahil Thakur. In what scenarios can an organization process personal data without explicit consent under the DPDP Act?
Yeah, so those are the instances that I just mentioned about. I was mentioning about certain exceptions that are there for the state instrumentalities and other categories. Um, so those are the ones, if you're doing it for research, for archiving, for statistical purposes, and the other categories that I mentioned, if you're doing it in a lawful manner, if you are doing it for a legal purpose, and if you're doing it in a manner which is consistent with the standards, and if you're doing it for providing subsidies, certificates, licenses, so on and so forth. So basically, and effectively, everything that a government does to provide services to citizens, that is more or less covered here.
Understood. Thank you for that, Mehak. The next question is from Ankit Vora. Does DPDP Act rule will have an impact on the overall annual financial statements, statutory audit, and any standard disclosure required to be made, especially for the companies registered under Companies Act?
Yeah, so it will. I don't know if this impact is from a cost standpoint. So if the question is that do you have to mention anything on your, in your audit reports or financial statements, or anything under the Companies Act with respect to the DPDP Act compliance, as of now, nothing in terms of any specific mention. However, from a financial standpoint, if there is cost that is incurred on compliance, or if there is a penalty that has been incurred, or if there is an ongoing case under this particular law that you need to mention as part of your contingent liability in your financial reports, then that's something that you would need to do as a matter of practice. So that's that. I think I also saw another question where the question was that we may have handled data of our
Yes,
clients, and
coming to that.
is there going to be our responsibility or not? And one of the other question I think I read somewhere was somebody sent me this question that I am an HR professional, and if this is going to be my obligation, how do I learn data protection? So I think on both of these questions, whose obligation is it in the company, or how does one learn? How does one handle? All I can say is that when it comes to the entire corporate setup, of course, eventually it is, um, the company's obligation as far as the government is concerned. But internally, there are going to be teams that are going to be responsible for the way they manage the data. Because if an event happens because of which the company is going to be liable to pay a hefty penalty, they are going to make certain processes and policies, and they will ensure that the employees comply with it. So, in that sense, there is going to be some amount of accountability put on the employees to be able to, ensure that they are following the basic practices. But there is nothing to be scared of. I don't think the idea is to individually target employees of a particular corporate setup, or to make one team responsible. It's not like just the HR team is going to be responsible, or just the IT team, or just the legal team. I think it's about just bringing about their change in culture, because ultimately it's for each one of us, that all this exercise is for each one of us. So the point that I'm trying to drive is that all of us are going to benefit out of it. It's all of our data that we are trying to secure. So it's not like we have to look at it from a third person's eyes to say it is somebody else's data. It's also our data which is being processed. So you look at how much of our data is circulating, and then the whole exercise will become simpler. Think of our data lying with the telco companies, think of our data lying in the banks, think of our data lying with insurance companies, and the potential scenarios of those being misused. And hence, all of this becomes even more important and contextual.
Thank you for that, Mehak. And moving on to, we'll just take a couple of last questions. This question is from Sucha. As per labor law, the time of retention shall be limited to 3 to 6 years. But the organizations like EPF, etc., will serve a notice way back of 2013 or 14. So, how do we balance and retain, say, maybe only challans, etc.?
So I think your questioning is that if we are storing the data under a particular law, and there's a longer time period for that, and you are you supposed to delete it within 3 years of the threshold I spoke about? So yes, what you need to consider is that if there is a particular law, labor law or income tax law or RBI law, or for that matter, any other law that requires you to retain the data for the purposes of that particular law, which is longer than the time mentioned under data privacy rules, which is 3 years, then yes, you would do it. So if you're supposed to retain all your labor notices and your data and your challans and employee data, so on and so forth, so for whatever period that you are under labor laws, so you will retain it under that period, because even this law provides for that. DPDP rules are saying that wherever you're processing the data, you will erase it unless the retention is necessary for compliance with any law for the time being in force. So if you to comply with labor laws or income tax laws, you need to, store the data for a longer period, then you go ahead and do that.
Okay, thank you for that. I'll just take one last question from Roshan. Roshan, how does DPDP 2025 address deemed consent, and what safeguards are in place to prevent misuse?
Yeah, I think there are two questions in respect of deemed consent. So, in fact, the rules talk about specific consent. In fact, if you see Rule 3 of the draft rules 2025, they mention how the notice is to be given. So the notice has to be in a clear and understandable format. It has to be in clear and simple, plain language. It should have the details in an itemized form of the personal data and of the description of the goods and services for which the processing is being done. And along with all of this, a communication link has to go through the website or the app to the person whose data is being used, so that they can exercise their rights, and if they want, they can withdraw the consent. And they should also know about all of their rights, including making a complaint to the board. So this is the level of consent that they are talking about in the rules, and they're also talking about having a consent manager, which is a whole together different organization or a setup which is incorporated in India. It has its own net worth requirement, it should be of high reputation, so on and so forth. So I mean, as far as the rules are concerned, they are not giving a lot of leeway to be able to do away with this consent requirement. Of course, once these rules are notified, then we'll have a much better idea of how these sort of reconcile with the law that the government had notified in 2023. But since the question is that, how is a consent or the deemed consent regulated under the 2025 rules? The 2025 rules are very clear on the kind of consent notice that needs to go and the requirements of the consent manager also. So I think in that sense, these rules are giving very less leeway. And I also saw somebody ask this question that, we should probably have data inspectors internally who can track all of this. But if there are people in the ID team or in the HR team who can also take up the roles of being um, data protection or data privacy managers, then I think that workload is something that can be managed by them. Also, I think the consent manager who are going to be running these platforms through which these consents would be given, their role becomes extremely important. So instead of, probably having data inspectors internally, it would be better for corporates to be able to sort of convert the current profiles into data management profiles and also focus on, the internal policies and grievance mechanisms and so on and so forth, so that they have a robust mechanism in place.
Great. Thank you so much for that, Mehak. And this was all. I think we're done with the questions, most of those. But if there are any follow up questions, or if you want anything specific that you want to understand, we'll be sharing a thank you mailer with all of you with Mehak's email ID. So you can get in touch with her directly if you have any queries. And I'm sure she would be happy to help out. Apart from that, we also have a Great Tribe community where we have experts like Mehak who can help you with any questions related to tax, compliance, HR, payroll. So you can sign up to this community and have access to these experts who can help with any questions that you might have. So thank you so much once again, everybody, for joining in. We also have our WhatsApp channel. You can see the QR code on the screen. We would be happy to connect with you here on WhatsApp as well. If you have any questions related to our customer support, product, promotions, or these webinar sessions that we have been doing, you can connect with us there as well. Also, as promised in the beginning, we will share the recording of the session today with all of you very soon. And this also will be available on our official YouTube channel. So you can always go there and watch it later. Once again, thank you so much, Mehak. It was wonderful to have you here today. This conversation was very, very insightful. And I think, as I said in the beginning, I'm going to have a recap and, go watch it again to understand the nitty gritty of this law and, how much of an impact it's going to have, both as in, it's going to have on organizations as well as individuals. So thank you so much for being here with us today.
Thank you. Thank you so much, Raki. Thank you so much, greytHR team. Thank you so much, Parichay team. And it was great to be here. Absolutely my pleasure. And we had a great audience. So, yeah, in case anybody has any questions, feel free to forward those to me. And looking forward to our collaboration. Thank you so much.
Thank you so much for that, Mehak. And thank you so much, our lovely audience today, for all those questions that you asked, thought provoking questions, I must say, that you asked and participated in the polls to make it more interactive and engaging. Also, before we wrap this session, I'm just going to put another sessions registration link in the chat. I'm sure it's visible to all of you. It's going to be on Union Budget 2025, which was announced on Saturday, last Saturday, and we're going to be decoding all of that in the session. So feel free to sign up. It's going to be a free webinar. You can share this registration link with your within your network as well. Anybody who wants to attend, they can register for this webinar. So looking forward to meeting you all on the 18th now. And thank you so much once again, Mehak, for being here with
Thank you
us.
so much. Thank you, everyone. Thanks, Raki. Bye.
Thank you, everyone. Have a great evening ahead.